Hello UPSC 2027 English medium aspirants. In this video, we are going to cover the Vision IAS monthly magazine. So basically this particular part will cover the April 2026 monthly magazine. Okay. Now let's start with the polity section. So the first section is related to polity, and in that the first current affair is related to Lok Sabha passes Jan Vishwas amendment bill. So in a very simple sense, let's try to understand this entire thing. Government want to improve the ease of doing business in our country. What is ease of doing business? Understand, a few terms are important from your exam perspective. One is EODB. What is EODB? EODB is nothing but ease of doing business. How convenient is it for any company to set up business in our country? Apart from that, there is one more term, regulatory cholesterol. Regulatory cholesterol basically means excessive regulation is acting as a barrier in the growth. Just like we have cholesterol which act as a barrier in the blood flow, similarly excessive regulation is acting as a barrier in the economic growth. So what government is saying, let's do one thing, let's simplify the rules and regulations so that people do not face problem in implementing these rules. Okay, so that is the entire issue. Now for that purpose the government has passed this Jan Vishwas bill. Now in a very simple sense, the objective of this bill is to simplify the rules and regulation. That's one thing. Second thing, a lot of offenses are now decriminalized. What does that mean? Decriminalization basically means previously, let's say filing a particular paper, previously there was a criminal punishment for that, let's say 1 year jail for that. Now government is saying, okay, instead of jail, just impose the fine. Even that fine is going to be in a graded manner. What is this graded manner? Let's say for the first violation, let's say there will be fine of 500 rupee, then second, let's say fine of 2000 rupee, and so on. That is a graded response. Okay, so these are important things. Now let's have a look at the headline. Lok Sabha passes Jan Vishwas amendment bill, which focus on the decriminalization and rationalizing the minor offenses to promote the ease of doing business and living. Now you can understand this entire article on your own as well. Okay, so basically Lok Sabha passed this Jan Vishwas again 2026. Now in this case the approach is trust-based governance. What is this trust-based governance? In a very simple sense, the government trusts its citizens that they will follow the rules. For example, let me give you a very basic example. There is a concept of self-attested document. Self-attested basically means you are signing your document and you are saying that these documents are genuine and I am not providing any wrong information. That is basically trust-based governance. In a very simple sense, government is saying, okay, we trust you and therefore we will accept it as a genuine document. What would be alternative? Alternative is that, okay, get it attested from some government office and so on. So that will further complicate this entire process. So we have discussed the decriminalization part. We have discussed the omission of offense. That simply means previously certain issues were offense. Now they are completely eliminated. And then there is a graduated response. In a very simple sense, it is kind of graded response that based on repeated violation, the fine will be increased. Apart from that, there is a provision of voluntary compliance. Voluntary compliance basically means the citizens will provide information, and this is kind of an expansion of the social contract theory of Rousseau. Now understand, what is this social contract theory? First thing first, Rousseau has mentioned this in the book, and the book was basically introduced in 1762. The name of the book is Social Contract. Okay, in a very simple sense, citizens are going to give up certain rights. In response to that, government is going to provide certain services. That's a basic concept, social contract theory. Now what we are saying is that when government is governing, it is going to trust its citizens, just like the citizens have trusted their government, that this government is going to work for the welfare of the citizens. So that is the basic concept. Now apart from this, what else is being done? So one of the most important thing is digitization. So for that purpose, DPI is there. What is DPI? Digital public infrastructure. So government is working on the digital infrastructure so that services can be provided in a faster manner, in a time efficient manner, and there will be less concentration of the power in the hands of the bureaucracy. Okay, so that's why it is quite important. Now in that context, one portal is there. For example, for environmental clearances, previously previously the process was quite complicated. Now government have basically set up one portal. The name of the portal is PARIVESH. So it can be directly asked that the PARIVESH portal is related to what segment. So it is related to the approval of the environmental process or environmental clearance. Apart from that, there is a term DPI. What is DPI? In a very simple sense, DPI simply means that the government is setting up infrastructure which is digital. For example, UPI is there, ONDC is there. These are nothing but DPI. ONDC is for e-commerce, UPI is for digital payments. Apart from that, DigiLocker is there. This is similar to Google Drive. So basically it provides the facility to store your data. And then there is a app, Umang app, which will provide all these services at one place. Okay. Next topic is related to Census 2027. First thing first, please remember two things. One is caste survey and one is census. Caste survey can be conducted by the state government, various state government, for example, Bihar, Karnataka, Telangana, they have conducted their caste survey. On the other hand, census is in the domain of the central government. Okay. Now, 2027 census is going to be the 16th census. Now, just have a look at the headline which is mentioned in the PIB. World's largest census exercise begin with house listing and housing census. So first, in a very simple sense, we are just making a database of the houses. Okay. Now, in that context, this is going to be the first ever digital data capture. Digital data capture basically means that the data is collected through digital devices. Okay. Now, the moment I mentioned digital devices, you need to keep cyber security in mind. So that can be considered as a challenge, that how we are going to maintain such a large database by protecting it from the hackers. Okay. Now, apart from that, there is a self-enumeration facility. Self-enumeration facility basically means you can register yourself in a very simplified sense. Okay. And who became the first person to do so? So, of course, the president became the first to complete the self-enumeration. So, a very straightforward kind of statement can be asked, that who was the first one. And just to confuse you, examiner will write the name of the prime minister. Again, if you know this thing, usually the president is referred as the first citizen. So logically, you should be able to follow this information. So this is the president doing self-enumeration. Okay. Now understand 2-3 important things. Originally it was planned in 2021, but because of COVID it was postponed. That's one thing. Second thing is that it is going to be a first fully digital census. Third thing is that it will have the caste data. Now understand, at a lot of places it is mentioned that this is going to be the first census to collect caste data after 1931. Understand, this is partially correct statement. In 1931, caste data was collected and released. Based on this data, subsequently after Mandal Commission recommendation, the reservation was given. So this reservation of 27% to OBC is based on this 57% population. 50, just a second. Okay, so 27% reservation was given on the basis of 52% OBC population as per 1931 census. In 41, the data was collected, but it was not released. So data collection was done in 1941 census. After independence, subsequently SC and ST data was collected, OBC data was not collected. So that's why it is important. Examiner can set a trap here, and you need to remember that data was collected in 1941, but that was not released. Caste data I am talking about. Of course, rest of the data is always collected. So this is something which you need to keep in mind. Okay. Now, basically it is in the entry 69 of the union list. That simply means the central government can conduct the census. State government can conduct survey, but not the census. The term is quite important here. Examiner can simply set a trap here. Okay. Now, this is mentioned as per the 7th schedule, Article 246. And basically the apex level authority is that RG, that is Registrar General and Census Commissioner, which is under MHA. Again, there is one more possibility of trap. Examiner can set a trap that Ministry of Statistics and Program Implementation is the apex level organization for this kind of exercise. Please remember, usually for data we have MOSPI, that is Ministry of Statistics and Program Implementation, but in this case it is MHA which is handling this entire exercise. So you need to understand the difference here. Okay. Now, if we talk about the first synchronous census, so synchronous basically means at the same time the data was collected in the entire country. So it is kind of a coordinated exercise throughout the country. Okay, so that was conducted in 1881, and at that time the census commissioner was W.C. Ploden. So that is something which is a factual information you need to keep in mind. If the question is about first systematic non-synchronous basically means the data was not collected at the same time in the entire country. So non-synchronous was done between 1865 and 1872. If the question is about first synchronous, then the answer would be 1881. And if I need to discuss the number or facts related to this thing, so 2027 census will be the 16th census, and this will be the 8th after independence, and the authority to conduct this is as per the provisions of Census Act of 1948. So basically this provides the statutory backing to this entire exercise. Now certain factual information again, for self-enumeration 16 languages are there. Now again, what examiner can do, examiner can simply set a trap that all the languages which are mentioned in the 8th schedule, self-enumeration is allowed in all those languages. Now if you don't know about this particular fact, then it will be quite difficult. So a easy way to remember that this is our 16th census, and that's why 16 languages are allowed. Of course, there is no direct correlation. This is just a way to remember the information. Now, there will be two sub part of this entire exercise. First phase will be kind of house listing, and second phase will be the population enumeration. So in house listing, we are trying to collect the house data from April to September 2026, and the population data will be collected, or the collection will start from February 2027. Now understand, for caste one more census is there, or basically a socio-economic caste census, SECC of 2011. Please remember one thing, that collected data, but that data collection was not properly coordinated. For example, people were asked to select their caste. In a very simple sense, someone will come and will ask your caste. Okay, you will tell the name of that caste. The problem with this approach is that the same caste can be known as different names in different areas. So what will happen? Caste A may be known as some other name in Rajasthan, may be known as some other name in let's say UP, maybe known as some other name in Delhi. So what happens is that there will be same caste, but it will be considered as a very different caste in different areas. And that's why what had happened, which is quite surprising, that roughly there were 41 lakh caste and subcaste group as per SECC, that is socio-economic caste census. And that's why basically this data does not make much sense, because you cannot have this much wide classification, and that's why this data is not in public domain. It is as per the media report itself. So you need to remember this. This is going to be 46 lakh exact data. This is 46.7 lakh. Caste and subcaste group were classified. Of course, that is why from policy perspective it is not that much useful. Of course, for other purpose, I'm talking about purely from caste angle. For other purpose, for example, providing benefit to the poor, in that case SECC is still relevant and it is being used. As per the 1931 census, we had roughly 4,147 caste. Next topic is related to AI governance and economic group. Now understand, the government constituted a technology and a policy expert committee, TPEC, to provide expert advisory support to India's AI governance architecture. Again, this is news headline from the PIB, and that's why it is often said that some sources are quite important for UPSC aspirants. PIB is one such source. Newspapers, especially The Hindu and Indian Express, their articles are quite important for UPSC aspirants. Okay. Now, in this case, there can be a question related to TPEC. What is TPEC? Okay, so this is going to provide the advice on the AI governance. Secondly, which ministry had set it up? So as you can see in the news itself, it is the MeitY, M-E-I-T-Y, that is Ministry of Electronics and Information Technology, that has constituted this TPEC, and it is advisory body. Second thing, what examiner can do, examiner can say that it is going to give binding advice, as usually they do. So just remember, this is advisory body. What kind of advice it is going to provide? It is going to provide advice related to AI governance. And for AI governance, there is one more body, that is AIGEG. What is AIGEG? That is AI Governance and Economic Group, and this is interministerial body. What is interministerial body? In a very simple sense, from different ministries. So why government is following this different ministries approach? This is basically referred as whole of the government approach. You can use this in your mains answer. If we have to tackle any problem, usually the problem is having multiple dimension, and therefore we need to collaborate with different ministries. This is basically referred as whole of the government approach, in which different department, different ministries of the government come together to address that problem. Now please remember that this body is going to be a 10-member body, and it will be chaired by the Minister of Electronics and Information Technology. Again, examiner can simply say that okay, this will be either chaired by some secretary level official, or will be chaired by, let's say, by Minister of Science and Technology. But remember, it is under MeitY, not under DST. And the members include the principal scientific advisor, chief economic advisor, and CEO of NITI Aayog. Okay. Now the moment you see the members, it is quite logical that if you see the higher level officials are there in this particular body, and that's why it is quite important to have someone of ministerial level to be the chairperson. And who is going to give advice? That is TPEC. Now as far as AI is concerned, we have already covered this in our AI part, that is in the February 2026 magazine. Please read it properly. Question has been asked in UPSC prelims. If you are appearing for other exam, let's say CDS, CAPF, so in that also they can directly ask question from it, because it was quite important issue, and that is the AI strategy of India. So it is based on 7 sutra. You need to keep that in mind. And as far as AI framework is concerned, it is Manav framework. Next is related to 131st Amendment Bill, which was defeated in Lok Sabha. So first, let's have a background of this entire information. 2-3 important things. Government provided reservation through Nari Shakti Adhiniyam, the provision of reservation for women, okay, in Parliament. Now, for that, there were 2 important conditions. One, first, there will be new census. Based on the data of that new census, there will be delimitation. So the argument was that it will delay the entire reservation thing. So in a very simple sense, first there will be census. It is going to collect new data. Based on that new data, there will be delimitation. Delimitation basically means we are going to redraw the constituency boundaries. And because of that delimitation, there is a opposition by the states who have controlled their population. They are saying we have controlled our population, and if we are going to readjust these boundaries on the basis of population, then of course we are at loss. Why we are at loss? Because they are saying that we have controlled our population, so we have less number of people, so our representation will be reduced. That is the entire argument. Okay, now so first there will be census, then there will be delimitation, and then there will be reservation. So that is the original sequence of event. Government said this is going to take too much time, so why not to implement this earlier? And for that to happen, this bill was introduced. The bill was 131st Amendment Bill, but it was defeated. See, for a bill like this, it required 2/3 special majority. That simply means the majority then normal majority was required. Okay, now the strength of the house is, again I'm telling you few factual information so that you can understand it better. You need not to mug up it exactly. Of course, in some exam it can be used as a statement as well. Okay, strength is 528, so it got 298. The desired number was 352 votes. Okay, so that's why it was defeated. Now understand, we have discussed what was the problem with the 2023 legislation. The 2023 legislation provided that reservation will be given to the women after the census. There will be delimitation and then there will be reservation. So the sequence of the event is CDR. What is CDR? C stands for census, D for delimitation, and then there will be reservation. That was the sequence. Government said we want to do it earlier. That's why they introduced this bill. So what this bill tried to do, it said that we can use old data. Why to wait for the census, new census data? We can still use old data, and based on that old data we can basically provide reservation earlier. That was the argument, but it was opposed. So basically two important things. It proposed the increment in the seats of Lok Sabha from 543 to 850 members. Out of those 850, 815 were supposed to be from states and 35 from the UTs. Okay, now understand, this was being opposed that those states who have controlled their population, they will be given less representation, and that's why there was opposition. It also tried to amend the Article 334A to implement the 1/3 reservation which is given to the women, which was supposed to be implemented after the new census. So we want to change that original provision that after the new census it will be applicable. So we are saying, okay, let's use the existing data, that is old census data, to implement this reservation. However, the bill was defeated, so of course now it doesn't make any sense. That simply means now the reservation provision will be effective once we have the data from the new census. Then there will be delimitation, and then there will be implementation of reservation. So basically the criticism is that it is very difficult to do it in the upcoming Lok Sabha election. So most probably it will be implemented by 2034. That is the entire argument around it. Next is related to promotion and regulation of online gaming rules. First thing first, the government tried to regulate the online games, and basically two categories were created. One is certain category of the games, online games, were basically prohibited. Why they were prohibited? They were more or less gambling. Other type of online games are still allowed. So for this entire regulation, this act was enacted, and subsequently the government introduced the rules. The name of the rules is Promotion and Regulation of Online Gaming Rules 2026. They are issued by MeitY, again ministry is important, and they are issued as per this act. What is the name of the act? Promotion and Regulation of Online Gaming Act of 2025. So act is of 2025, rules are issued in 2026. Who have issued rules? That is MeitY. Okay, now basically it categorizes the online games into esports. That simply means the game which we play, the online version of that. Okay, then online social games and online money game. Now, in a very simple sense, examiner can simply say that it has prohibited all type of online games. No, it has not. Basically, it prohibits the form of online money game. Why? Because they promote kind of gambling, and it allow the previous two category, that is e-sport, this is allowed, and online social gaming, that is allowed. Now for the regulation of this entire thing, OGAI has been set up. What is OGAI? That is Online Gaming Authority of India, and it is under Ministry of Electronics and Information Technology. The headquarters is going to be in Delhi, and there will be 6 members, and the chairperson is going to be the additional secretary of MeitY. Again, examiner can set a trap that this will be chaired by MeitY minister, but in this case it is the secretary, additional secretary to be specific. Now it talks about a 2-tier grievance redressal mechanism. What is this 2-tier grievance redressal? First, there will be internal grievance redressal mechanism. Internal basically means, in a very simple sense, let's say you have an issue with some gaming company. You are a player and you had issue, so you are going to file a complaint in that particular company, and they are going to work on this complaint. If they don't take any action on your complaint, so now you can approach the government body. So two important things, one is internal complaint, that simply means within that company, and second, you can appeal against it, and you will have 30 days to appeal. And once you have appealed, then the government body need to resolve your case within 90 days. So this is going to be the timeline of the event, 30 plus 90 days. Next topic is related to Rajya Sabha, and this is quite important. You need to understand. So the deputy chairperson of Rajya Sabha was recently elected, and this deputy chairperson is basically a nominated member. So very straightforward question can be asked in exam, that nominated members cannot be elected as the deputy chairperson. This is one such example, so you need to keep it in mind. Now understand the news. So nominated member, nominated basically means I'm talking about Rajya Sabha. So in Rajya Sabha, members can be nominated, and nominated member Mr. Harivansh Narayan Singh, please remember previously he had served as the deputy chairperson for 2 terms. Okay, so he was later nominated, and subsequently after nomination he was elected as the deputy chairperson. In a very simple sense, let me explain the timeline of the event. So he was already the deputy chairperson of Rajya Sabha. His term ended. After the end of the term, he was again nominated. Previously he was serving, term ended, he was nominated. After being nominated, he was again elected as the deputy chairperson. This is 3rd term for his appointment as deputy chairperson. So this is something you need to keep in mind. 2 traps can be there. A, examiner will make a statement like nominated members cannot be elected as deputy chairperson. Second statement can be that a deputy chairperson cannot have more than 2 terms. Nothing like this exists in the constitution. So of course that's why the person has been basically elected for the 3rd term, and this is 3rd consecutive term. As far as Rajya Sabha deputy chairperson is concerned, please remember as per article 89, the deputy chairperson is elected from the members. Now understand one more trap. The statement says elected from the members. This process is going to be through election. Members can be nominated. Members in Rajya Sabha can be nominated. Members in Rajya Sabha will also come from states. 2 type of basically membership will be there. One is through nomination, and one members will come from states. So you need to understand these traps, so that if examiner set these kind of trap, you can bypass them. Now as far as the Rajya Sabha nomination is concerned, so as per article 80, 12 members can be nominated, and they can be nominated in these category, that is literature, science, arts and social service. Now please remember one thing, at state level there is one more category, that is cooperative. So from that perspective, there are more category for nomination at state level. Please remember one more thing, nominated member can participate in the debates, they can vote in the vice presidential election, but they cannot vote in the presidential election. In presidential election, basically the nominated members cannot vote. Now, can they join political party? They can join a political party within the 6 months. Can independent member join the political party? This is something which you need to answer in the comment section. Is it possible for a independent member to join a political party? If so, that simply means if they join a party, will anti-defection be applicable in that case? Next is related to removal of judges. So basically former High Court judge Yashwant Verma, basically he resigned. A case was going on, case or inquiry was going on against him. In that context, please remember one judgment, that is Veeraswami judgment. What is this Veeraswami judgment? Basically, as per this judgment, FIR cannot be directly filed against the higher judicial officials. First, they need prior approval from the CJI. So that's why there was a controversy that why no FIR or why no action was taken against this particular judge in this entire case. The reason is, as per Veeraswamy judgment, it is not possible. Okay, and that's why a lot of politicians also raised question against it, and they demanded that this judgment need to be reviewed. So you just need to remember that this judgment simply says that direct action cannot be taken. Okay, now the removal process has already been discussed in the previous months, so I'm not going to repeat it. Please watch it from there. One more trap which can be set up by the examiner, that the entire process of removal is mentioned in the constitution explicitly. No, for that, for detailed provision, we have Judges Inquiry Act of 1968. Next is related to recusal of judges. Now understand this entire case. So basically the former Chief Minister of Delhi was basically contesting his own case, and he said that the judge who is involved in this case, I'm having a thought that the judge may be biased against me, because the judge is having some inclination towards other ideology. That was the entire argument. Now, from exam perspective, you need to understand what is recusal. Recusal, in a very simple sense, means recusal means that someone else is going to hear this case, because either there is a conflict of interest, and that's why the fair judgment will not be possible. So the judge is saying that, okay, I'm not going to hear this case, I'm out from this, someone else should hear this case because there is a conflict of interest. That is basic sense of recusal. So this was a case related to the excise policy issue. Now, in that context, please remember that state government have the power to impose excise duty on liquor. That can be asked in economics as well. Now, please remember one more thing, that we don't have any explicit codification of this entire process. It depends on the discretion of the judge whether they want to recuse or not. However, there are certain case laws. For example, Ranjit Thakur versus Union of India and Chandra Prabha versus Union of India. These are two important precedents, but explicitly it is not codified that in what circumstances they need to recuse themselves. Next is Commonwealth Parliamentary Association. So recently the meeting of this association of Region Zone 7, this was organized in Goa. This is the headquarters of this Commonwealth Parliamentary Association. So the headquarters is in London. It was founded in 1911. As the name suggests, it is for the collaboration between the parliaments of different countries who are the member of this grouping. Okay, and they also publish one journal, that is the Parliamentarian. Okay. Next is related to NCERT. So basically NCERT has been given the status of deemed university, and that's why it was in news. In a very simple sense, what is the benefit of deemed university? It can provide its own degree now. So apart from designing curriculum, now it can also provide the degrees, and that's why it is important from NCERT perspective. So this is the headline: NCERT get deemed university status. So now it can grant a degree and it can expand the research. And since it is a university now, it will have to follow the regulations set up by UGC. What is UGC? That is University Grants Commission. So NCERT has been given the deemed to be university. So NCERT is under Education Ministry, and the headquarters is in New Delhi. And with this, we have covered the polity section of April 2026 Vision IAS monthly magazine. If this session was helpful for you, please write down your feedback in the comment section. Apart from that, the PDF of this entire lecture can be downloaded from the Civils Academy app. Thank you.